Hi, everyone. I'm David Williams, president of strategy consulting firm Health Business Group and host of the HealthBiz podcast, a weekly show where I interview healthcare leaders about their lives and careers. Well, today's show is going to be just a little different because we're going to be talking about whistleblowers. And my guest today is John Tycko from Tycko and Zavari, LLP. He represents whistleblowers under the False Claims Act, and he's also a podcast host. So it should be a particularly good show. We'll have to remember who's going to be asking and who's going to be answering the questions. But if you do like this episode, I really hope that you're going to subscribe and ask your friends to do the same. John, welcome to the HealthBiz podcast.
Yeah, thank you. Thank you for having me.
Great. Well, we were just chatting before the show, and I heard that you actually live near where I grew up, and my wife went to my same high school as maybe even in my class. So I don't know how many more questions I should ask, but love to hear a little bit about your background and what your childhood was like, any childhood influences that have stuck with you for the long term.
Well, I grew up in a town called Stony Brook on Long Island in New York. And although I'm a lawyer now, that was not my ambition when I was a 6-year-old child there. I actually grew up in a family that was very science oriented. Both of my parents and both of my older brothers, all PhD scientists in various fields. My wife is also in a scientific field. Both of my children are in scientific fields. So somehow in this family of scientists, they managed to create one lawyer.
That's good. Well, you are keeping the scientists safe from the troublemakers by helping the whistleblowers straighten things out. So it seems like a pretty clear path.
I mean, I do get to use a little bit of my science brain in my law work now. So that is fun.
That's good. Well, when I was growing up, my father, who was a social psychologist, I think there were only two things he didn't want me to be. One of them was a lawyer, so I didn't do that. But the other, I think, was an economist, and I did study economics. So he just thought that in economics, they assumed away all of the interesting stuff, like all the psychology, and just said, assumed like the Homo economicus, like the perfectly rational economic creature. So.
Yeah, that is true. That is true. Although I think economics is starting to change a little bit in that
It's
respect.
come around.
They're being invaded by psychologists and sociologists a little bit.
Yeah, this was a few years ago. I don't know which was worse. At least you knew that it was kind of an artificial construct. Whereas today, they may overemphasize, they have overconfidence in what they've actually been able to do. Nonetheless, so I know you went to law school, but when you were coming out of high school, what was the path that you pursued educationally?
Well, at that time, I again, like coming out of a family of scientists and being surrounded by those folks, I sort of assumed that's what everybody did. I went to college at Johns Hopkins, started out as a physics major, thinking that was the path I was going to be on. But somewhere along the way, I kind of fell off that path, not for lack of interest. To this day, I'm very interested in physics and science, but it had more to do with sort of career path and wanting to do something different. At the time, both of my brothers were in grad school, and the career path for academic scientists seemed difficult and rocky.
Yeah.
And so I switched to being a history major because I think that was the only major that I could still finish on time with by the time I decided to get out of physics. So I switched to history, and then it was a question of, well, what do you do with a history degree?
Right.
So law school it was.
No, it makes good sense. I mean, I think you were right at the time that you were coming out. It was tough to make a living as a scientist, and it was also just before hedge funds really took off, and they needed physicists and mathematicians after that. So we missed out
Right.
on that wave, but probably all for the best. So I think you did the typical thing, prestigious thing coming out of law school. Did some clerking. What was that like?
Yeah, so one of the jobs you can get coming out of law school is to be what's called a law clerk to a judge. And so that's what I did. I was a law clerk to a federal judge. And the law clerks are kind of the judge's assistant. So you work kind of hand in hand with the judge, doing research on legal issues for the judge, helping the judge draft opinions, just running the courtroom, stuff like that. So it's a great first experience coming out of law school. It was a fantastic learning experience for me. And I did that for 2 years coming out of law school. They're usually fairly short-term jobs. Yeah. And then from there went into private practice at a law firm.
Nice. And so after you did that for a while, then you decided to start your own firm. What was the thinking behind that, or were you left with no choice?
No, no, no. I had plenty of choices. I mean, I was, again, I did sort of a fairly traditional path for lawyers, which is that, as a young lawyer, I tried to get a job at a big established law firm, which I did, a firm called Gibson, Dunn and Crutcher in Washington, D.C. Fantastic firm. And, I did the stuff that a young associate does at big law firms. You work a lot of hours and you get a lot of experience very, very quickly. But I was never really particularly interested in kind of building my whole career around the type of work that large law firms do. The largest law firms are typically also representing the largest corporate entities. They're often, in the world of litigation, which is what I do. They're more often on the defense side than on the plaintiff side. And I always saw myself as more of a little guy lawyer.
Yeah.
I kind of prefer to be on the plaintiff side and to represent, the interests of individuals. And so me and my partner, who was also an associate at that same firm, we became friends while we were there. And, over the course of a couple of years, we would kind of kick around this idea like, hey, what would happen if we just left and started our own firm? And we eventually kind of worked up the nerve to do that, not really knowing what we were getting
Yeah.
ourselves into. And that was now 20 years ago. And now we have a firm of close to 30 lawyers. And we do exactly the kind of work we were hoping to do.
No, that sounds terrific. So I know a lot of what you do has to do with whistleblowers, and that comes about under the False Claims Act. I know there's maybe some other related sorts of laws that are out there, but what is the False Claims Act? What's the history of how that came into being?
Well, the False Claims Act, the original version of it, was passed during the Civil War. It's often affectionately referred to as Lincoln's Law. It was a law that Lincoln pushed for and signed into law. And it was primarily designed at that point to try to fight what people called war profiteering. The Union Army would be sort of moving through the countryside and would have to sort of buy supplies along the way, and would often be sort of taken advantage of by people that would sell them, rotten meat or guns that didn't work or, what have you. And there was no real effective enforcement mechanism at the time. So the idea of the False Claims Act, what the False Claims Act makes unlawful is essentially committing fraud, financial fraud on the government or on government programs. And the law has been amended many times over the years. And the major amendment happened in 1986 when it added what's known as a qui tam provision. And what that means is that a private citizen who has information, non-public information, that a fraud is being committed, can bring a case in the name of the government. That's what qui tam means. It means you're filing the case, but on behalf of the government, to recover the monies that have been obtained by fraud. And so that's kind of the idea of the statute. Where it intersects with healthcare, the stuff that your audience is primarily interested in, is that these days about 60 to 70% of False Claims Act cases are in the healthcare world. And that's largely just a function of how much money the government spends to pay for healthcare. And because there are so many providers, so many companies that are sort of billing through that system, any sort of healthcare fraud often will end up violating the False Claims Act and could give rise to one of these whistleblower cases.
Got it. Okay, very interesting. So it's really since '86 is kind of the modern era with whistleblowers and qui tam. I was asking before the show how to pronounce your name, and so you saved me the trouble. It sounds like you're not done with. I've seen people pronounce it. It's QUI. It's like Qui or something like that. We were just actually having this discussion yesterday because IQVIA is a contract research organization. Some people pronounce it IQVIA. So this is easier. Qui tam.
Well, even within the bar, not all lawyers pronounce it the same. So nobody's really sure.
No one remembers the original Latin. Nobody's that old to be able to do it. So how does the concept of the whistleblower tie in? That whistleblower is maybe a concept that existed before the False Claims Act, but this is actually a way that kind of ties it together under qui tam, that a whistleblower becomes really prominence and an important figure in the whole False Claims Act.
Right. Yeah. So whistleblower is not like a technical term of art in the law. But I think colloquially, most people would think of many of my clients as being whistleblowers
Yeah.
in the sense that they are someone who is, inside the organization, be that a hospital, a pharmaceutical company, even a large physician practice. There's somebody who works inside the organization who believes that something unlawful is occurring. They're often in the position of having tried to go through whatever the internal compliance mechanisms are
Yeah.
within the company to try to fix it, and they're not seeing the problem fixed. So they, quote unquote, blow the whistle. And one of the mechanisms for doing that, not the only mechanism, but one of the mechanisms for doing that is through one of these False Claims Act key TAM actions.
Got it. So give me an idea of a typical case. You sort of described why a lot would occur in healthcare. Maybe give me a non-healthcare case. Like where would be an example that you would see that kind of a key TAM case from a whistleblower, and how would it actually all work out?
Outside of healthcare, you're asking? Well, sort of the next biggest bucket outside of healthcare is government contracting. So just all of the other companies that are doing business with the government. And so there could be fraud in the bidding process for government contracts. There could be, there's a lot of fraud in sort of set-aside contracting, fraud in the delivery and billing for goods and services. So, all of the things, sort of just commercial fraud type activities, but where the purchaser is the government.
Got it. And
Yeah.
so within healthcare, I mean, I think you give an example of a lot of, maybe billing with Medicare or something like that. What would be a case there, and how does it work through, and kind of how long does it take, and what role does the whistleblower play, and what happens to them along the way, and then at the end?
Yeah. Well, okay, that's like 5 different questions.
No, I know.
I'll start.
We have time, but you know, you're
Okay.
saying it's sort of like the concept is there. All right, I blow the whistle. Usually, like my son's a hockey ref. You blow the whistle and play stops, and it's done. You know, but it's not a little more complicated here.
It's definitely more complicated and not that quick. These cases are multi-year cases. So one of the first things I always tell people who approach me and are thinking about doing this is that this is not a silver bullet. It's not a quick fix. It's not going to stop whatever the problem is tomorrow. You are at the beginning of a process, and that process takes time to roll out. In terms of, I think the first question you asked is sort of what are the types of cases we see in the healthcare realm. And so I can kind of give you a real quick sort of thumbnail sketch. I think of them as falling into about 6 different buckets, biggest buckets, if you kind of looked at all the cases that have been filed over maybe the last 10 years or so. So like bucket number 1 is marketing, things that can go wrong in marketing. And that can include off-label marketing, and violations of what's called the anti-kickback statute. So using improper incentives to try to sell pharmaceuticals or medical devices primarily. And then the second bucket is physician referral. So there's a whole nother law, the Stark Law.
Yeah.
I'm sure folks in your audience know about that, but this is a very complicated technical law that deals with when physicians can make referrals to other physicians or other companies with which they might have an interest. So that's another area where there are sometimes cases. The third bucket is just in treatment. Some cases involve medical necessity questions. These are just providers that are treating their patients for problems they don't really have, or are greatly overutilizing certain kinds of treatments. If that's done intentionally for financial gain, that would be a violation of the False Claims Act. The fourth bucket happens in the billing for those services. That could be upcoding and unbundling. This is sort of playing games with what are called the CPT codes, the billing codes. The fifth bucket is manipulation of capitated payment systems. This is primarily, Medicare Part C, what's called Medicare Advantage. And this usually involves playing games with diagnosis codes in order to make a patient population seem sicker than they really are, in order to increase payments, capitated payments under those systems. And then the last bucket is just everything else. There's every year there's something new. There's some new government program. Every time the government creates a new program with a new bucket of money, somebody will try to find a way to take advantage of it.
Yeah, got it. So, all right, so you could see this sort of whistleblower insider see something that is going to violate the False Claims Act, as you've described it, which could be a lot of things where the government is involved. They
Yeah.
usually try to go through channels to try to have it fixed, and by that time they're frustrated. Their moral compass is telling them, this isn't the right thing to do. And by the way, there's a provision here in the law to be able to do something about it. They might find you or somebody else. And then it takes years. But what happens, like what role does that whistleblower play after kind of the the initial reporting? Is sort of, okay, we just let you know about it. You take it from there. You let me know if it's successful, or what's usually the involvement.
No, it's a little more than that. The whistleblower actually does play a very important role, particularly at the beginning of the case. So procedurally, what happens is there is an actual complaint, a legal complaint that is filed in court the way any other lawsuit would be filed. But that complaint is secret. It's filed what's called under seal, which means the defendants, the company that you're accusing of the wrongdoing, does not know that the case has been filed, at least initially. Instead, that complaint goes to the Department of Justice, and you also provide the Department of Justice with what's called a disclosure statement, which is essentially a memoranda addressed to the Department of Justice explaining what the evidence is that supports your allegations. So this could be, documents that the whistleblower might have, other witnesses, whatever the information is that is going to support the allegations that are made in the complaint. And then the Department of Justice, which has a whole team of lawyers that do only these kinds of cases, they will open an investigation into those allegations. And usually one of the first things they do is they will sit down with the whistleblower, with the relator, that's the technical term under the statute, with the relator, and conduct a fairly long interview. It's an off-the-record interview. It's there for purposes of fact-finding for the government lawyers and the government investigators. Often HHS investigators are involved. And they'll try to extract as much information as they can from that individual who's brought the case, who often needs to explain to those investigators, here's how this company works, here's what the documents look like, here's the right way to read them, that type of thing. So the whistleblower plays a key role at the beginning. Now, once that interview happens, the government is then going to go out and do its own investigation. They don't just take the whistleblower's word for it. They will look at billing records, medical records, whatever they need to look at in order to determine whether they think the fraud is actually occurring the way the whistleblower alleges. And they do that somewhat independently from the whistleblower. They don't just take the whistleblower's word for it. And so we, as the whistleblower's lawyer, one of the main roles we're playing at the beginning is kind of vetting and making sure that what this person is saying is defensible.
Yeah.
By which I mean, is there evidence in support of it, right? I mean, sometimes people will come to us with stories that may well be true, but they can't really come forward with any evidence to show that it's true. And we would view that as a fairly weak case, not one that's really worth pursuing. But often people come with some evidence, and that's what we help them put together.
Got it. So then the DOJ needs to decide whether they're going to bring a case
Right.
after they've spoken with the relator, they've done their own investigation. And then what happens when they either make the decision to bring a case or not to bring a case?
So if the Department of Justice decides that they want to take over the case, which is called intervention, they will come in. The DOJ lawyers will come in and take over the case effectively and litigate it on behalf of the government. And if that happens, then we, as the whistleblower's lawyer, sort of play a backup role. We're protecting our clients' rights. We're helping the Department of Justice in whatever way they need help, but they're going to take the lead. If the Department of Justice decides not to intervene, then typically the whistleblower has an option at that point to pursue the case on their own with their own lawyers. And if that's the path that the client wants to take, then we, as the whistleblower's lawyer, take the lead. We run the litigation, we do the investigation, and the Department of Justice kind of sits on the sideline. We still sort of tell them what's going on. They're still there to protect the government's interests, but they're letting us take the lead in the litigation.
Got it. And when the Department of Justice decides not to take a case forward, not to pursue it themselves, is that a bad signal for you? I mean, does that basically say that's a loser case, and if the whistleblower wants to be able to fund it or something, it's okay? Or can there be a situation they say, no, that's actually a strong case, and maybe DOJ even saw it that way, but it's better pursued by the private party?
It could be either one. So usually when the government gets to that point, if they're going to decide not to intervene in the case, the DOJ lawyers will sit down with us and give us some explanation for why. And whether we decide to then go forward with the case on our own depends a lot on what we are told about the government's reasons.
Got it.
So it could just be, you're wrong. It didn't happen the way your client says it happened. Okay, and in that case, we're not likely to pursue the case on our own. We're more likely to go back to the client and say, look, it just didn't happen that way. Maybe the billing, sometimes we have clients who are somewhat siloed within the organization. So from when they're sitting, it looks like there's a fire because they see all the smoke. But then really something else was happening in the company that they weren't aware of. Maybe the bills didn't really look the way they thought they looked or whatever. And so we would advise that client, let's not go forward. Let's just dismiss the case and be done with it. Sometimes the DOJ lawyers will come back to us and say something different. They might say, yeah, it actually did happen the way you said, but there's some other reason why we've decided to just let you go forward without us. And sometimes that could just be purely resources. They get lots of these cases. They have to decide where to put their resources. And if we have a $10 million case, but they have $500 million cases to work on that week, they may just decide this one's just not that important to us, but it still may be a case that's perfectly worthwhile for us to pursue.
Got it. Okay.
Yeah.
And then could you explain just sort of like the financial element of this? Because there's a whistleblower is entitled to compensation, presumably if what they report turns out to land with a recovery for the government. Is that right?
Yes. So there is a financial incentive built into the statute, which was intended to incentivize whistleblowing. And so the way that works is that under the law, if the government recovers money, then the relator, the person who brought the case, can get anywhere between 15 and 30% of that recovery. So again, imagine a $10 million recovery. The relator is going to get somewhere between $1.5 million and $3 million as their sort of award for having made that recovery on behalf of the government.
So in other words, $10 million, which could be small for the federal government, even after, working through what it's going to cost to, have your services and getting to the end of the road, could still be worthwhile financially for a whistleblower to pursue it, as opposed to that's just a nice little payment, and it could be quite meaningful.
Oh, absolutely, and that's why we often do pursue those cases, even when the government declines.
Got it.
Yeah.
So I've understood, I've heard anyway, that being a whistleblower, it sounds very good. Maybe whistleblower doesn't sound good, but relator, so it's like you report something, somebody's defrauding the government, you go through a process, and if it works out, you're going to get something at the end of the day. But I've also at least heard that there's could be retaliation, that you could just not just from the company, but your overall people maybe don't want to hire a whistleblower somewhere else, and it could be just kind of a tough road to go down. And that's, of course, may happen before you get your payoff. It's one thing if you go and you get, let's say, your 1.5 to 3 million, or your 10 million or 50 million, or whatever you may get. That may be one thing, but this could happen to you even before you find out if this is going to occur. But can you explain a little bit more about it? Am I off base with that, or is that a kind of a typical situation?
No, you're not at all off base. And this is a concern that almost everyone expresses to us when they come to us thinking about doing this. And it's one of the areas where, we as the lawyers have to advise them. So particularly in the healthcare world, I have found that the potential whistleblowers often are very concerned about retaliation. They often have a lot invested in a particular career. Often that is a career that is somewhat niche in the sense that they may be working in a particular town, in a particular part of the country, in a particular subspecialty of medicine.
Yeah.
And if they get a bad reputation in that small community, it could be really very difficult for them personally and professionally. And so this is a very serious concern. And we've certainly had people who we thought had potentially good cases who decided not to pursue them for exactly that reason. The law does have what's called an anti-retaliation provision, so that there is a remedy if you are retaliated against, but that doesn't mean that you're not going to be retaliated against.
Yeah.
It just means that if you are, you might be able to sue somebody for it.
Yeah.
So it's sort of cold comfort at that point often. So this is definitely something that whistleblowers have to take into account. And they have to sort of be prepared for it. I mean, the cases are filed under seal originally. They don't stay under seal forever.
Yeah.
What we typically tell people is you could count on probably 2 years of anonymity after you file the case. But at some point, once the government makes that intervention decision, the case becomes unsealed. At some point, your name is going to be out there on a legal document that if somebody went looking for it, they could find it.
Yeah.
And it's just, that is something that people have to take into account. And there's, what I found is that the whistleblowers who are successful and kind of stick with it tend to have a certain set of personality traits that are somewhat unique. I mean, psychologists have actually studied this. Most people in large organizations have a very strong instinct to kind of go along to get along.
Yeah.
Like even if they feel the organization is doing something wrong, the natural tendency is to kind of just put your head down, stick to your technical task. That's somebody else's problem. Somebody else will fix that, and to maintain your little network of friendships in the company and all that. There's a very strong psychological bias against doing what whistleblowers do. So the people who do come forward, either they've really become seriously disillusioned by the organization, or they're just people that are kind of like uniquely justice centered. There are some people who are just they're rule followers. They have a strong sense of right and wrong. Sometimes they have a very strong sense of patriotism, and they just have motivations that allow them to overcome that bias that most of us have. I mean, I think we can all say that we would be brave in those circumstances, but the reality is most of us wouldn't.
Yeah.
So the whistleblowers tend to have a real strong sense of identity, a strong sense of right and wrong, and sort of less susceptibility to kind of groupthink, I guess is what I would say.
Interesting. So going back to this point about the share that the whistleblower can get between 15 and 30%, which is not an incredibly wide range, but it's still, double, 130 is double 15. Is it clear from the outset what that rate is going to be? And then do you also have the situation where someone can go through all of this angst and anguish and time, and then the government decides, well, you're not actually entitled to anything because we were working on this anyway, and you're not actually a whistleblower and you don't get anything?
Well, sure. I mean, there's a certain percentage of cases that are not successful for all sorts of reasons. I mean, you can lose a lawsuit for lots of reasons that, and it's not always because you were wrong.
Yeah.
Things can just go wrong procedurally. Companies can go into bankruptcy along the way. And so you have no chance of recovering, even if you were right. Sometimes you can be so right that the government converts your case into a criminal case.
Yeah.
And now the company is really going to be in peril because the CEO is going to be in jail and the whole business is going to be shut down. So you've accomplished something from a societal perspective, but there's not going to be any money for it at the end.
Yeah.
So lots of things can go wrong. There's definitely some risk of that occurring. Yeah.
Yeah. How about the 15 versus the 30? Let's say for your case, it's more down the middle. Is it clear this is a 15, this is a 30, or is it sort of like it's after the fact?
No, because where you fall in that range actually has more to do with kind of where in the process the recovery occurs.
Okay.
So if the government does an investigation, intervenes and settles right away with the defendant. So really at that point, maybe all that you've done as the whistleblower is file the case, sit for an interview with the government, provide them some information, but then the government has gone and done the rest of the work and reached a settlement on its own. In that circumstance, you're going to be closer to the low end of that range. Yeah. At the other end is a case where the government has declined. You've now decided to go forward with the case. And let's say you have to take the case all the way through trial to win. You win a verdict. You're now 6-7 years after you filed and you finally get your recovery.
Yeah.
In that set of circumstances, you're going to be closer to the top of the range.
Well, so the economist in me likes that, because it actually makes sense in terms of aligning the incentive with the level of effort and the time frame for it. Good. So if someone has, they're seeing fraud and they go through the channels, which they might not have to go through the channels, do they actually have to go through the channels at the company first? Or they see fraud, they could just come right out as a whistleblower if they want. They just don't tend to do that.
Yeah, it's not a technical requirement of the statute. There's often good reason to try to do that, but
yeah. Yeah. Okay. But so let's say if somebody's, found a fraud against the government, they want to be a relator, whistleblower. What would you advise them to do? Someone who maybe listening to this podcast, for example.
Well, I mean, you're going to have a lawyer. These are not cases you can do on your own. So shop around and find a lawyer that you're comfortable with and that knows this area of the law. It's a relatively small niche bar, so there aren't that many of us, but there are some of us out there. And then you do, like as I previously said, the difference between successful cases and unsuccessful cases has to do with what type of evidence can you show the government at the beginning to make the government lawyers and investigators take your case seriously? Because you're trying to activate government resources, and those resources are limited, and they're not cheap, and the Department of Justice is careful about where it deploys those resources. So the cases that are going to get the most attention are ones where, when they look at the case at the beginning, when they open that file and they sit down with your client for the first time, there's already some evidence there in front of them that makes them think, oh, what this person is telling me is true.
Yeah.
They're credible, and what they're telling me is in fact something that violates the statute. So it's really that evidence gathering and development and presentation that we help the client through at the beginning that is important.
Got it. So, John, at the end of my podcast, I always ask the final question about any books that people have to recommend. But you actually get two final questions because you're a podcaster. Okay. So my first question is, what's your podcast about? And the second question is if you have any books that you would recommend.
Oh, okay. Well, thanks for asking both of those questions. So my podcast is called The Garrulous Gavel, and I interview other lawyers. I don't talk about what I do. I kind of sit in your chair,
right,
and just ask the questions. So it's not about me marketing my practice, but I try to find other lawyers who are doing interesting things, and we try to have fairly long discussions. It's sort of a long form podcast. They're often hour and a half long discussions about some interesting legal issue or legal case or legal development that the lawyer's involved in. And we try to talk about it in a way that allows somebody who isn't a trained lawyer to kind of understand why this issue is interesting and to start to think about it critically. And we also delve a little bit into the lawyer's histories, why they became a lawyer, kind of their growth in the legal industry, why they were interested in that. And so that's the nature of the podcast. So if you have any listeners who are kind of curious about law and lawyers, The Garrulous Gavel, give it a listen.
Sounds good. And then do you have any time for reading books other than professionally? Anything that you recommend?
Yeah, no. I'm still an avid reader. I guess I would say, can I mention two quickly?
If you can, yeah.
I mean, one is probably the most recent book that I read that I really liked, and this is kind of going back to my roots as somebody who was interested in science and physics. The most recent book I read that I really liked is called Existential Physics, written by a theoretical physicist named Sabine Hassenfelder. And she, there are certain people in the science world who are just good at sort of explaining the science to people who aren't in their little, sphere. And she's really, really good at explaining kind of the cutting edge world of theoretical physics and kind of giving it kind of like a skeptical eye. So this book is sort of designed to tackle kind of the big philosophical issues in physics about where did the universe come from? Where is it going? What is the nature of reality? But doing it skeptically and saying, here's what we really know and here's what we really don't know.
Got it.
So that was a very fun read. The other one I would say that I always love and that I think anybody in the medical field should read is a book called The Knife Man by Wendy Moore. And this is a history of an 18th century surgeon in London named John Hunter, who was a very cutting edge, no pun intended, surgeon in London in the 18th century who was an early anatomist, and he lived just a fascinating life. And it's a great portrait of what London was like in the 18th century that involved him basically paying grave robbers to dig up corpses and sneak them in the back door of his London townhouse so that he could, do dissections on them and try to learn about the human body while parlor games were being played in the front room of his
Nice.
house. And it's just a very evocative book, and really teaches you a lot, I think, about how far medicine and healthcare has come in such a short period of time, because the way that medicine was practiced then compared to the way it's practiced now is night and day. And this guy was right at sort of the beginning of the scientific revolution in medicine, just at the very early stages. And so just a couple of 100 years ago, not that long ago, doctors really knew almost nothing.
Yeah.
That's the picture that you get from this. They didn't even understand about germs. And they didn't even dissect. They didn't even clean their knives before they started their surgeries. So it's just a very fun, kind of gory, but fun read.
That sounds great. Well, John Tycko from Tycko and Zavari, I want to thank you for joining me today on the HealthBiz podcast, talking about whistleblowers, relators under the False Claims Act. Thank you so much.
Thank you, David. It's been fun.
You've been listening to the HealthBiz podcast with me, David Williams, president of Health Business Group. I conduct in-depth interviews with leaders in healthcare business and policy. If you like what you hear, go ahead and subscribe on your favorite service. While you're at it, go ahead and subscribe on your second and third favorite services as well. There's more good stuff to come, and you won't want to miss an episode. If your organization is seeking strategy consulting services in healthcare, check out our website, healthbusinessgroup.com.